Alrighty.
We have launched.
Okay, then. Very good. Thank you all for joining us tonight. This, of course, is Planet Green Trees. It's officially episode number 193. We're calling it Give Me Back My Cannabis. Today, of course, is April 3rd, 2014. Calling numbers 1-347-326-9626. For those of you sharing the efforts that we're trying to bring to the community, you can tell people to visit the www.planetgreentrees.com. And welcome, everybody. As I said, I'm your host, Michael Komorn, and we are going to be bringing you tonight the most up-to-date, informative, and relevant medical marijuana and marijuana reform information. Joining me in the studio tonight to help do all that is Chad from the Birmingham Compassion Club.
Good evening. It's nice to be here.
Missing, but I understand on the way, is Rick Thompson from the Compassion Chronicles, and one only bringer of the news week after week. Jamie Lowell, the proficient producer of the show week after week, bringing great guests, is also unaccounted for, but I understand running late. And Sharmi, do not attribute the latest to Sharmi. I know it would not be her fault for any timeliness issues. And we will hear from them. I think they're on their way and will be here shortly. But also, joining us in the studio, a good friend and colleague, David Radoy. David, welcome.
Happy to be back. It's been a couple months, but very happy to be here at the radio show.
Very good. And David, of course, although he's not slotted, we may have to do an entirely separate show. We're going to try to get some talk in on his opinion that he argued before the Michigan Court of Appeals this past, the opinion came down in the last couple of days. What's the name? Musner?
Cynthia Ann Mazer?
Mazer.
Yep.
And we're going to hear from David a little bit more about that. But tonight, we're going to be talking about the U.S. Supreme Court denied the writ of certiorari filed by the state of Arizona, resulting in a final ruling which affirmed a Court of Appeals ruling ordering the Yuma County Sheriff Leon Wilmott to return the medical marijuana he seized from a one and only Valerie Okun, California medical marijuana patient visiting Arizona. The sheriff ignored the fact that Arizona law has reciprocity. In other words, they honor card-holding medical marijuana patients from other states. Michigan happens to be one of those states, likewise, who maintains a reciprocity section in its law. The sheriff used the familiar arguments that federal law trumps state law with regard to marijuana and refused to return the marijuana he seized from Valerie Okun, California patient, even after the Arizona courts ordered him to do so. We're going to be talking about this a little bit tonight. Additionally, unfortunately, an environment that we still live in, this idea of entrapment, we're going to be joined by brother counsel and medical marijuana attorney and doing all kinds of stuff over on the west side of the state, our friend Dan Groh. He was and has been representing an individual by the name of Jeffrey Miller, and in his courtroom challenges, he was arguing entrapment. He's going to be joining us to talk about the recent Michigan Supreme Court's denial of the application for leave to appeal, leaving undisturbed the trial court's opinion, which denied Mr. Miller his medical marijuana defense at trial. Miller's appeal stemmed from allegations of the illegal delivery of marijuana resulting from an undercover cop entrapping him or pretending to be a suffering patient with no access to marijuana. The officer tricked Miller to sell marijuana after showing him forged patient card and a matching driver's license. And this is an interesting case in time. As many of you know, Komorn law and Rudoy law and Amberg, some other lawyers successfully defended the Carruthers case in an entrapment defense whereby the circuit court judge in Oakland County dismissed the charges, finding that the behavior of the police was reprehensible. In this case, as we're going to hear from Dan Groh, is interesting. We're going to ask him some questions about what impact and just some of the details and how this plays out in regards to issues that were raised in the Carruthers case. Also, it is April in Michigan, and it is Tiger baseball is back in play, and of course, one other event that we all like to acknowledge and wallow in is Hash Bash Monroe Street Fair this weekend. It is, of course, the legendary and one and only really event of marijuana reform in Michigan. And calling in to discuss this is our legends, Ed Rosenthal, Nick Zetell, and Charlie Strackbien. Of course, I'm going to rant in a little while, and we're going to hear news from Rick will be here. I see that accounted for now is Jamie Lowell, producer. As I say every week, if anyone has any complaints about the show, call Jamie. He's responsible, not me. Sharmy Golson is here, the one and only Sharmy. Welcome.
Hi, Michael.
All righty. So there's always so much to talk about, and but for Jamie looking over the monitors and pointing at his watch as I begin to rant, I would go on for all 2 hours on my own. No, just kidding. But I do want to talk about a kind of a menagerie of things. The first one is our show discusses this, Give Me Back My Cannabis. Now, this is an interesting discussion, debate, and legal issues, and kind of consistent with what I ranted about last week, and I think which is an important point to make again. I don't create this news. I don't create these arguments. I just am pointing out the ridiculousness by which they're being used. But as it went in Arizona, the California resident was arrested, marijuana seized, charges later dropped because the prosecutor in that jurisdiction recognized that their law, Arizona's medical marijuana law, acknowledged a reciprocity of other states that had medical marijuana patients. So the charges were dismissed. She was not able to get her marijuana back and challenged this issue, went to the Court of Appeals, and later the federal court. Application to the U.S. Supreme Court was denied. And when that happens, it means that the Supreme Court did not feel it necessary to disturb the ruling. In other words, the last ruling that existed, which is that they must return marijuana to Ms. Okun, stands. And the Supreme Court does not need to disturb that. So, and as it goes, is this state sheriff of Yuma County argued and asserted that federal law trumps the state law with regard to marijuana and refused to return the marijuana he'd seized even after the Arizona courts had told him to do so. He's not employed by the federal government. He's not a federal agent, not DEA. And the state court, the same one that employs the judges and employs him as well, ordered him to do so. Now, for some reason, this rings a bell of something going on in Michigan. And as last week I was not short of material because he's such a easy topic to discuss, but the obsession of our Attorney General with medical marijuana and his desire to write about it, describe it, and discuss it, as I lamented last week, has never been positive, not once, not really taking the voters' will at heart as he argued for the same-sex marriage ban of 2004. We've never heard him argue for states' rights for medical marijuana. And likewise, every chance he's had to argue for states' rights, he has, except in medical marijuana. I described last week his position in regards to all of these other issues that those of his party, in the tradition of his party, stood and argued against overbearing federal government intrusions, the 10th Amendment protections of not allowing the federal government to compel the states to act on their behalf, and likewise authored by our Attorney General, who's literally done, I would say, nothing to assist in the voters' will. And that's my big complaint. I mean, you can be against it politically. You can have an opposing opinion, but the least you could do is make a concerted effort and take your job seriously in trying to assist the community in some way of implementing the law, not just making it a public safety issue and arrest first, ask questions later. But In his obsession with addressing this issue, he was asked a question, and as outlined in his opinion from Attorney General Opinion number 7262, he's asked whether law enforcement officers who arrest a patient must return marijuana found in the possession of the patient or primary caregiver upon his or her release from custody. And while he goes through and outlines very well the law of the state of Michigan and how it does demand it, and how marijuana shall not be forfeited under the law, and all the protections of returning it should exist, and any law that would conflict with it, he even points out Section 7E, the law that determines when there are laws in conflict, the Michigan Medical Marijuana Act, wins. He goes through all of this, outlining the strength of the Act and its protections, and then concludes that for an officer to return the cannabis would be a violation of the Federal Controlled Substance Act, as if the existence of the Michigan Medical Marijuana Act and the voters' will to implement and use this law to protect individuals under state law is meaningless to our Attorney General. He goes on to argue at great lengths about preemption and Federal Controlled Substance Act and all of the arguments that were used in Tierbeck versus Wyoming, which were shut down by the Michigan Supreme Court. It's all the same arguments used in Arizona. It's all the same arguments that his opponents in the gay marriage ban in federal court argued. So if there was ever a question in terms of the flip-floppiness, I think it's very clear. And I'm glad to see that there's a serious recognition of this returning of the medicine, and that Michigan can now expect that this ruling would have some impact on their return of medicine in those situations. And I think it's something that should be utilized and argued in all those circumstances when somebody's either released from custody or, at the minimum, if the charges are not authorized. All right, I'm going to do another. Jamie, I've got a couple more minutes. Don't I see 6 minutes? 30. 6 minutes. All right, I wanted to just point out, it was, it's interesting to me that Colorado, of course, legalized marijuana for adults 21 and over, but one of the underreported factors is that there's an increase in driving offenses related to marijuana. It's a tragedy, and it's unfortunate, and it goes to what I describe as for some reason, the negotiation of being able to have marijuana legal for adults required the relinquishment of sanity for the regulation of drivers who happen to use marijuana. And a lot has been written about this, and the point of, I think, the most of the stories is that the testing that has been done regarding marijuana in the blood and driving has never really established any kind of baseline of what would be intoxicated. And I would argue that it's impossible to do so. Colorado and Washington State, relinquishing in what can only be described as challenging negotiations, ended up with a 5 nanograms of THC in the blood as a basis to be considered per se impaired by cannabis, which is just absolutely outrageous. But the point is that many of the tests that have been done are merely to determine the presence, never a number. None of the studies give us any kind of rational number. But I want to take that argument one step further, which is that, especially in light of the fact that we know states that have taken a position of much more tolerance, still there remains a focus on some kind of regulation, some kind of challenge, some kind of illegal activity that somehow warrants the police to still get a bite of the apple, to still get some money to bring in the courts, to still keep that docket busy. After all, we have all these probation officers. We have to feed them and their families, and if we can't be drug testing these terrible people driving around, and then what are we going to do? So, but my point is this, that in addition to not being able to determine an exact number, if one is charged with a driving with, under the influence of cannabis, remember that the actual accuracy of the results should always be challenged. And what I mean by that is, in the case that I've had my experiences over and over and over again, the state lab produces a single result of THC in the blood. We're talking about delta-9 THC, the active ingredient from smoking marijuana. And that number is reported as one number, and it's usually like a 10, 15, or 20. Not a 15.03 or a 20.01 as you would think is a scientific number. It is a 20. It's not even a number that a scientist whose valuation of any kind of analysis is going to be based on accuracy and precision. The number 20 is the opposite of accuracy and precision. Yet this is how the state police reports it over and over again. Additionally, they report one number once. That means that if asked to determine what in fact is the percentage of error of that result that they are reporting, they cannot provide one. In fact, if you ask them if the test was taken again, what they could predict it to be, they can't provide an answer to that. And they can't predict what the next one would be and the next one would be after that. And problems with this arise because this is a new trend in Michigan as well. More and more classes are being offered for training for officers in drug recognition expertise. There's no question that in light of the trend of marijuana reform, there's going to be an explosion of expert police officers who are going to describe behavior that they're going to determine and testify to because of their training experience as a drug recognition expert why it's dangerous. And they're going to scare jurors. This is the direction that things are going. And my point is that it's comical because other than the fear and creating some kind of junk science of an expertise of what drug recognition expertise even is. And the premise, of course, is that as it goes in the war on drugs, if a police officer comes in and they've got their uniform and their badges to shine real nice and they've trained at some school, they think that they are going to convince a jury, make people feel comfortable that their activity, their process, their place in the world, those jurors. And they think they're going to win that argument time and time again versus the pot smoker. But I'm suggesting, amongst other things, in the challenges of these cases, we understand the following. Number one is that in Michigan, a patient who has a card, the mere presence of cannabis is not enough. Even THC, delta is not enough. That, in fact, an additional factor must be established, that being evidence of impairment. We are grateful to the Michigan Supreme Court for finding that way in People v. Kuhn, recognizing that the Michigan Medical Marijuana Act, when it conflicts with the other laws of the state of Michigan, here in the Motor Vehicle Code, the Michigan Medical Marijuana Act wins and it trumps those that conflict. And a new element had been established by the courts, ironically, in a statutory scheme. But so remember that when challenged, remember that there's going to be an attack on this, and we're seeing it already, and they're building a police force to do it. But more importantly, remember that these lab results, this is the same lab that said they could not measure the amount of THC in a brownie, to wit, People versus Carruthers, which has caused a lot of problems throughout the state. That is not an accurate statement. They have the same machinery that any other tester of marijuana, that any other caregiver would go to test it. It's the same machine, but they just don't have a protocol to do it. Likewise, they don't have a protocol to actually determine what accurate rate, what the rate of accuracy would be in the retesting. Science is defined as accuracy and precision. As my good friend Carl Ebner, an expert that we've called upon a number of different times, he's called into the show. He's been pivotal in other cases that we've had, trials that we've won. And as he explains to the jury, if we're sitting around, ladies and gentlemen, the jury, and we are trying to place a bet on the sharpshooter, that would be the most accurate and precise of the shooters in the room. And we're going to give each of them an opportunity to show off their skills before we place the bet. And the first one steps up to the line and shoots and hits the bullseye. Are you going to place your bet then, thinking that that is the accurate result that is expected? Or do you want to see them shoot again a second time to see if they hit the bullseye in the middle a second time? Because only then do you know that they are the sharpshooting specialist, the bullseye, the accurate precision, scientific result of a blood test. Because when you only have one result, you don't know where the second one's coming from. It could be in the absolute opposite direction. And those are the kind of shenanigans that are part of this entire comedy of the increase of driving while under the influence of marijuana. And that's my rant. We got an exciting show. We got all kinds of law to talk about. We've got advocates, producers, news, and a lot of talk about cannabis. We are you're listening to Planet Green Trees. Call numbers 1-347-326-9626, and we'll be right back.